On this episode of Law Weekly, we bring you more of what transpired at the Senate screening of the 11 justices whose appointments were recently confirmed to the Supreme Court. Bayelsa State also appoints 2 new judges, with the governor of the state asking them to discharge their duties with humility. We also bring you highlights from the 2023 International Law Association ILA Arbitration Dinner and Awards with the theme International Arbitration, Putting Our House in Order. Plus our recap of the top trending legal stories in the news. Hello and welcome to the program. I'm Shola Shuyeli. It's no longer news that the Senate has confirmed the nomination of 11 justices to the Supreme Court. The confirmation came on Thursday, December 21st, a day after the lawmakers screened the nominees.
Request for confirmation of the appointment of 11 justices of the Supreme Court of Nigeria.
The President of the Senate, Senator Godswill Akpabio, reading President Bola Tinubu's letter during plenary. The letter requests the lawmakers to screen the 11 nominees for the Supreme Court and confirm their appointments as justices of the court.
I hereby present for confirmation by the Senate the names of the underlisted 11 appointed justices of the Supreme Court of Nigeria.
The Senate President subsequently referred the nominees to the Senate Committee on Judiciary, Human Rights and Legal Matters for screening and further legislative input. After plenary, the Committee on Judiciary, Human Rights and Legal Matters commenced the screening. At the exercise, Chairman of the committee, Senator Mohammed Tahir Monguno, spoke about the inadequate funding of the judiciary.
The 10th Senate and indeed the 10th National Assembly is a responsible and responsive assembly to the yearnings and aspirations of Nigerians that are clamoring for the legislature to jealously guard and protect the independence of the judiciary by ensuring that their welfare is adequately provided for, that they should insulate the judiciary from a scenario whereby they go cap in hand to the executive begging for funds to operate. And it was against this background that even in the current exercise of budget consideration, the Judiciary Committee had cause to suspend the consideration of the budget of the judiciary to invite the Minister of National Planning to show cause why the judiciary is not adequately funded, and we have gotten assurance that something better will be done.
The Senate leader on his part appealed to the federal government to ensure that the budget takes into consideration the appointments being made. He also appealed to the appointing authorities to ensure prompt recommendation and appointment of judges going forward to prevent prolonged vacancies on the bench.
So, my appeal on behalf of all of us to the appointing authorities is we need to avoid this kind of situation. These positions did not all become vacant in one day. As these vacancies occur, it's important that those who are next in line be screened and appointed immediately. I also want to say that what's happening here today also has its financial implications, and the budget of the Federal Republic of Nigeria must speak to it. So let it not be that after this exercise, the NJC will now be saddled with the responsibility of having to run from pillar to pole to ensure that my lords are able to settle down.
24 hours after the screening, Chairman of the Committee on Judiciary, Human Rights and Legal Matters submitted the report of his committee. He said the committee was satisfied with the nomination of the justices and therefore recommended their confirmation.
The committee examined their curriculum vitae and other supporting documents and thereafter screened them. There is no criminal record or adverse report found against the nominees, as record checks and other forms of investigation by relevant security agencies did not reveal any negative trace against them.
A debate followed the submission of the report, with senators supporting the call for the confirmation, while others dwelt on the need to improve the funding of the judiciary.
I therefore request that my colleagues to, without much ado, give our approval to this for the confirmation of this committee nominees, because everything that has been done here have shown that these people are properly put in place. They are well qualified.
The crop of the justices that have been presented here are, I will say, part of the best in Nigeria. For legal practitioners, if you read their judgments, you know what I'm talking about. But of particular note, Mr. President, let me thank the Senate. I know they will approve. For the first time, we have a Supreme Court justice from Plateau State, Justice Sankey.
Mine is particularly to call the attention of the legislature, the National Assembly particularly, and the executive arm of government, that our judiciary, like our legislature, needs more and more resources. Mr. President, distinguished colleagues, those of us who have interacted with our judiciary at this federal level, we know how hard it is for them to do their work and decide their mandates. The time has come, Mr. President, for both the legislature and the executive arms to give the judiciary a worthwhile financial attention.
But I want to join Senator Ahmed Lawal in begging the Senate to look at the budget of the judiciary, not only in the Supreme Court or Court of Appeal, even the magistrates, the state courts, they're in a mess. When you go to see a judge of a state court, you will think that is coming with Okada. Is living in the midst of the people he's supposed to judge. And these things are not the way they were before. Most of you who were governors and all the rest of them, we did better in providing accommodations for these people where they will live, quarters and all the rest of them, cars to go to work. So I plead with my colleagues in the Senate, let us look at the budget of the federal judiciary, especially also in the Court of Appeal and industrial courts, all the courts. And also, it is not right to leave justice of Supreme Court for so long. I'm adding my voice to former Governor Bayelsa, that you will live like Southeast. We are left for almost 7 years without a judge in the Supreme Court, entire Southeast.
After the debate, the lawmakers approved and confirmed the nomination of the 11 justices.
Will the Senate approve the nomination of Honorable Justice Mohammed Baba Idris for appointment as Justice of the Supreme Court of Nigeria? Those in favor say aye. Those against say nay. The ayes have it.
Those confirmed at the chairman of the 2023 Presidential Election Petition Court, Justice Haruna Samani, and chairman of the Kano Governorship Election Appeal, Justice Moore Adumain. Others are Justice Jumai Sankey, Justice Chidebere Uwa, Justice Chioma Nwosu Iheme, Justice Obandi Ogbunya, Justice Stephen Jona Ada, Justice Habib Abiru, Justice Jamaila Tukur, Justice Abubakar Umar, and Justice Mohammed Idris. With their appointments, the Supreme Court will now have the full complement of 21 justices as envisaged by the Constitution.
Now we move on to the 2023 International Law Association ILA Arbitration Dinner and Awards with the theme International Arbitration, Putting Our House in Order. Leading arbitration practitioners who spoke at the event called for a significant change in attitude towards accountability and integrity within the profession. We have more details in this next report.
The dinner, which held in Lagos, attracted members of the bench, senior legal practitioners, members of the arbitration community, and many other professionals. The president of the International Law Association, senior advocate of Nigeria, Professor Damilola Olawuyi, who joins the event virtually, invited more professionals to join the arbitration community. He also spoke about the importance of aligning arbitration practices in Nigeria with international standards and best practices.
In my own personal practice, I see arbitrators traveling to London, Geneva to resolve disputes that originate from Nigeria. And I think this should worry us, and this is probably one of the things we should reflect on tonight. Furthermore, recent events revealing the tendency of arbitrators to abuse the confidentiality of arbitration to perpetuate brazen conflict of interest and corruption should worry us as well. I think this event should be an urgent wake-up call for us to ensure that arbitration does not become a vehicle for corrupt parties to curb their crimes in the respectability of the institution of arbitration. Also, challenges of costly procedural delays using technicalities to derail the enforcement of arbitral awards and lack of clear training opportunities for young arbitrators are challenges that should indeed worry us as arbitrators, and we should think of ways to resolve them. I hope we will take the opportunity of the dinner to have some very frank discussions on how we can clean up the practice of arbitration and make it even more respectable than it currently is, especially making Nigeria a respectable seat of arbitration in the near future.
The representative of the ICC, in her goodwill message, also stressed the need to collaborate and bring dignity to the affairs of the arbitration community.
Indeed, we are in the times when we need to talk frankly with ourselves, when we need to really help in our engagements to bring about some kind of dignity in the profession that we are operating in.
The host, the chairman of the arbitration committee, Mr. Tolulokwe Aderemi, took center stage in advocating for change. He highlighted the decline in the reputation of arbitration practitioners and emphasized the need for a universal code of ethics.
As you will agree with me, this arbitration community has come under severe scrutiny, and that is why we're all here tonight, whether for legitimate concerns or otherwise. Either way, I am proud to say that Nigeria boasts of some of the best minds with exceptional intelligence, diligence, and persons of unquestionable character. However, it will seem there is a gap. We have no accountability partner. Our accountability partner may come in several forms. On this occasion, it may come in the form of a national code of ethics. The Chartered Institute of Arbitrators, the CPR Institute of Dispute Resolution, the National Academy of Arbitrators, and many others. They have provided simple guidelines tailored to specific domains. However, what we need is a universal code of ethics that addresses misconduct and its consequences. A most recent one is the infamous case of the Federal Republic of Nigeria versus the Process and Industrial Development Limited, the famous P&ID case, which has challenged our integrity and reputation as arbitration practitioners. Do we have a collective response to this? I am referring to the decision of Honorable Justice Robin Knowles of the London Commercial Court, a decision which will be referenced in every arbitral challenge under Section 68 as long as the Arbitration Act of England 1966 remains in force. It is also true that if we do not act fast and put our house in order, arbitration may become less reliable. It is also true that we need to introspect. What went wrong with that contract, or indeed other contracts? What went wrong with that arbitration, or indeed other arbitrations? What is this community's attitude towards misconduct and the removal of its reference in the new Arbitration and Mediation Act, AMA?
The keynote speaker, Mr. Babatunde Fagbohunlu, SAN, who also joined virtually, delivered a speech on international commercial arbitration, putting our house in order. He focused on the challenges faced by African arbitrators in accessing the global arbitration market and the significant arbitral awards against the Nigerian government. He also emphasized the need for Nigerian arbitrators to equip themselves for global opportunities while proposing the establishment of a single arbitration institution for the African continent to enhance its attractiveness and participation in international arbitration. This was followed by a fireside chat with Life Bencher and the first female Attorney General and Commissioner for Justice, Lagos State, Mrs. Hairat Balogun, who, amongst other things, addressed the ethical issues plaguing the legal profession.
The role of educating lawyers is purely on the laps of the Council of Legal Education. Who are members of council? Most of them are deans of law.
The event also provided an opportunity to honor some deserving individuals for their contributions towards the development of the arbitration community. Those honored were Mrs. Hairat Balogun, former chairman of the Arbitration Committee of the ILA, Mrs. Adedoyin Rhodes Viver, the chairman of Heritage Bank, Akin George Taylor, and the Attorneys General of Lagos and Oyo State.
Welcome back. We move on now to Bayelsa State, where Governor Doyediri has sworn in 2 new judges, one into the High Court and the other into the Customary Court of Appeal. The swearing-in was done at a brief ceremony which held at the Executive Council Chamber of the Government House in Yenagoa. The 2 new judges are Honorable Justice Amebi Orukari and Honorable Justice David Lawrence Okpokuma. The ceremony was witnessed by the Chief Judge of the State, Justice Matilda Ayeme, and the President of the Customary Court of Appeal, Justice Daniel Aya. Governor Diri, while giving his charge, urged the new justices to discharge their responsibilities with a deep sense of humility.
We cherish the ideal of a strong and a vibrant judiciary. Thus, since coming into office, the Prosperity Government has made very modest strides in creating the enabling environment to accord our judiciary the much needed independence. And we will continue to strengthen and support the independence of the judiciary through the appointment of more judges and judicial staff in the years ahead. It is a privilege today to celebrate the addition of these 2 erudite individuals to our judicial system. In an era where our society faces numerous challenges, ranging from complex legal disputes to social injustice, the role of judges becomes even more critical. Your decisions will shape the lives and destinies of individuals, families, and even communities. It is therefore imperative that you carry out your duties with utmost integrity, impartiality, and dedication to the principles of justice. I urge you to discharge your responsibilities with a deep sense of humility, remaining conscious of the enormous trust that has been placed upon your laps. The judiciary is often referred to as the bastion of the last hope of the common man. And it is your duty to ensure that this hope is not extinguished. Treat every case that comes before you with the same level of attention and diligence, regardless of the stature or background of the parties involved, be they rich or poor.
And just before we go, a quick recap of some of the top legal stories in the news.
We'll begin with the report that the Supreme Court has affirmed the election of Peter Mbah as the governor of Enugu State. A 5-member panel led by Justice Mohammed Garba held that the Labour Party and its candidate Chijioke Edeoga failed to prove the allegations of substantial non-compliance with the Electoral Act. The court also dismissed the allegations of NYSC certificate forgery, one of the bases for which the Labour Party governorship candidate wanted the court to disqualify Governor Peter Mbah. The Apex Court resolved all the issues in favor of the first respondent, Governor Mbah, who was the People's Democratic Party candidate in the March 18 governorship election. In the Kano governorship seat, the Supreme Court reserved judgment in the appeal filed by the governor, Yusuf Abba Kabir, challenging the verdict of the Court of Appeal, which removed him from office. The Court of Appeal had upheld the verdict of the tribunal. The 5-member panel, led by Justice John Okoro, reserved judgment after parties adopted their briefs of argument. At the proceedings, counsel to the governor, Wole Olanipekun, faulted the nullification of his electoral victory on the grounds of the INEC presiding officer failing to sign or stamp the ballot papers. Olanipekun also argued that it had nothing to do with the Electoral Act, insisting it is on INEC's guidelines and as such not sufficient grounds to deem the vote unlawful, warranting nullification. The court also reserved judgment in the Bauchi governorship appeal. Staying with the Supreme Court, a 5-member panel led by Justice Iyan Okoro has reserved judgment in the 2 appeals challenging the victory of Governor Babajide Sanwo-Olu. The panel reserved judgment after hearing argument in their appeals filed by Gbadebo Rhodes Viver of the Labour Party and Olajide Adediran Janjo of the People's Democratic Party. In his argument, counsel to Governor Sanwo-Olu, Chief Wole Olanipekun, told the court that the present case is different from what was pleaded at the appeal court. He stated that while the argument at the appeal court was on the deputy governor's renunciation of his citizenship, the case at the Supreme Court is on his acquisition of a U.S. citizenship. He subsequently asked the court to dismiss the appeal. At the Court of Appeal, also in Abuja, a 3-man panel of justices has affirmed Ahmadu Fintiri of the People's Democratic Party as governor of Adamawa State after dismissing the appeal of Aishatu Binani of the All Progressives Congress for lacking merit. In the judgment prepared by Justice Tunde Awotoye and read by Justice Ebiowei Toby, the appellate court also awarded the cost of 500,000 naira in favor of Fintiri and the PDP against Binani. The appellate court frowned at the premature announcement of the election outcome by the resident electoral commissioner Hudu Ari. And at the Federal High Court, Abuja, Justice Donatus Okorowo has barred the Independent National Electoral Commission (INEC) from organizing by-elections to replace 27 members of the Rivers State House of Assembly whose seats were declared vacant. Justice Okorowo also barred the defendants in the case from interfering with the 27-member camp of the Rivers State House of Assembly from conducting their legislative duties as Speaker, Deputy Speaker, and members of the Parliament. The judge restrained the Inspector General of Police and the DSS from denying or refusing to provide security to the 27 lawmakers or withdrawing their security details. He subsequently adjourned the suit to December 28 for hearing. Right Honorable Edison Ahie had last Wednesday declared vacant the seats of 27 lawmakers who defected from the People's Democratic Party to the All Progressives Congress. While Mr. Ahie is being backed by Governor Siminalayi Fubara, the 27-member group led by Martin Amewule is loyal to Nyesom Wike, a former governor and current minister of the Federal Capital Territory. And we round up with the sad report that unidentified gunmen have kidnapped a High Court judge in the Oron local government area of Akwa Ibom State, Justice Joy Unwana. Reports say the judge and her driver were whisked away by her abductors while the police orderly was shot dead on the spot. The incident occurred along the Uyo-Okobo Road while the driver was taking the judge to her home in Uyo after a court sitting in Oron. The State Public Relations Officer, Odiko McDonn, has described the incident as unfortunate, adding that the Commissioner of Police has ordered a discreet but thorough investigation into the incident.
And this is where we adjourn proceedings for today. Do remember to check out the Channels TV website for a replay of this episode of the program, as well as past episodes. Please also send in any feedback via our social media handles. I am Shola Shayeli. Thank you for watching and see you next week.